Pan with the Association of Prosecuting Attorneys. APA is a national nonprofit located in D.C. serving prosecutors as well as their law enforcement and community partners. Thank you for joining our final Friday's webinar series. Today's webinar, Prosecuting Hate Crimes, will begin shortly. Today's presentation is made possible by a grant received from the Office of Justice Programs through their Bureau of Justice Assistance. APA is very appreciative of their financial assistance and commitment to improving the justice system. By the conclusion of the webinar, you will be emailed a short electronic survey to complete regarding this webinar. This survey helps us continue to provide quality training to you at no cost to your jurisdiction and assist in future planning for continuing legal education. In appreciation of your completion of the survey, all surveys will be submitted in a drawing for a free one-year APA membership. During today's webinar, you will be able to submit questions for the speakers using the question box on your GoToWebinar toolbar located on the right side of your screen. These questions will be forwarded to the speakers and we will try to cover the issues during the live presentation. If you need additional assistance, please feel free to contact us or the presenters directly following the presentation. We are very excited for today's webinar presented by Joy Repella and Patrice O'Neill. Joy Repella is an Assistant State's Attorney with Cook County State's Attorney's Office in Chicago, Illinois. She played a key role in State's Attorney Anita Alvarez's commitment to returning to community prosecution to Chicago by spearheading the development of 4 community justice centers around the city. Joy currently heads the Northside Community Justice Center. Joy has over 20 years of prosecution experience with the Cook County office, including extensive experience prosecuting hate crimes. She has also served as part of a regular faculty group at APA's national and regional conferences. Patrice O'Neill is the CEO and executive producer of the Oakland, California-based nonprofit notinOurTown.org. It's a community-based movement of people working to stop hate together. She has produced the successful Not in Our Town national series on PBS and led a multi-platform approach that utilizes documentary film, social networking, outreach, and organizing efforts to encourage dialogue and community action. The series began as a half-hour PBS special and turned into a dynamic movement that continues to thrive in communities across the U.S. and around the world. Patrice and Not in Our Town are currently working in conjunction with the COPS Office of the United States Department of Justice to produce a new set of films, profiles, case studies, and online tools and resources designed to help communities continue the fight against hate crimes. Please welcome our presenters, Joy and Patrice.
Thank you. Hello from Chicago, Cook County, where we've got a lot of snow and cold, but a warm welcome from us anyway. Thank you for that introduction. I am an assistant state's attorney in Cook County and have worked both as a supervisor of the community justice centers now and then worked when they were called community prosecutions offices under a former state's attorney. Under that former state's attorney, our community prosecutions offices prosecuted all of the hate crimes for all of Cook County because Mr. Devine felt that hate crimes had a major impact on communities, unlike some other crimes that, although they affect the individual, they affect hate crimes really affect the community itself. So let's begin. Our Illinois hate crime statute, if you want to look it up, comes under 720 ILCS 5/12-7.1. The way a hate crime is based, at first you have to have it has to be by reason of a perceived or actual victim's race, color, creed, religion, ancestry, gender, sexual orientation, physical or mental disability, or national origin. You have to have committed the crime because of those reasons. Most importantly, before you even get to that, the first thing you really look at is whether the offender has committed a crime. Because basically what a hate crime does is it takes an underlying misdemeanor of a variety of sorts, and if you have, by reason of or actual perceived race, color, or creed as the motive to commit that misdemeanor, you then have a hate crime. So really where the conversation usually begins with our police and with our victims is first of all to see whether a crime has actually occurred. And in our state statute, the crimes are specifically laid out that are the basis or the misdemeanor basis that can become a Class 4 felony hate crime. And those misdemeanors you see in front of you: assault, battery, aggravated assault, theft, criminal trespass, mob action, disorderly conduct, harassment, and criminal damage to property. I'll spend a little bit of time talking about assault, but all of these others, like battery, of course, is an intentional touching that is offensive in nature. An aggravated assault is an assault where you're threatening somebody and you have a weapon in your hand. Theft, presumably everybody on this knows what a theft is. Criminal trespass can be both to real property, a victim's residence, or actually victim's vehicle. We actually try to stay away a little bit from mob action and disorderly conduct because our courts have not been so kind to those. Harassment is the one time where we can often use phone calls because it primarily results in telephone harassment, and then, of course, criminal damage to property. If you don't have one of these misdemeanors, it doesn't matter what the person says or how much of a jackass the person is that the offender is, you don't have a basis for charging a hate crime, which is why what we do, these are the issues that we experience here, and having prosecuted a lot of these hate crimes, the first issue you need to look at is, number one, is it a misdemeanor? If it's not a misdemeanor, you're out of the box. Because quite frankly, people have the right to be jackasses. They don't have a right to commit crimes, but they do have a right to be jackasses, have, beliefs that are offensive to others, say ridiculous things, and quite frankly, just be jerks. If they haven't committed a misdemeanor, there is no crime. So first you look at those underlying misdemeanors. Now I have assault here because assault can raise a red flag. We've had this as issues both explaining to victims who don't get a hate crime charged, as well as police officers and, quite frankly, sometimes other state's attorneys. Assault in Illinois means you have to be in a reasonable anticipation of receiving an immediate battery. And it has to be reasonable. So in other words, if I'm sitting behind my desk and I'm talking to someone across the room and I say something offensive like, you stupid white bitch, I'm going to hit your face, well, it's not an assault because I'm sitting behind my desk and they're across the room. So there's no reasonable apprehension at that point in time of receiving a battery. If I'm standing up and I say, I'm going to hit you, you white bitch, and I take a step towards her, or 2 steps towards her, and I'm walking towards her with my arm raised, that might be a reasonable apprehension of receiving a battery. So in other words, an assault is not something through a closed door, an assault is not something over a fence, and an assault is not something of future harm. I'm going to kick your ass. It's got to be, I'm going to kick your ass right now, and the person has to be moving toward you or have some action that makes you in a reasonable position to believe a battery is happening right now. Sometimes where it becomes difficult, not just with assault, but are with mixed motives. Because you can have both the motive of you just don't like somebody because they're gay or they're black or they're a woman or they're whatever religion, but also you might be involved in a fight with them or you hit their car and you're involved in a fender bender. Sometimes it becomes a mixed motive. And mixed motives, those are very difficult to not just charge, but prove. You've got to be very clear that the motive that the misdemeanor is committed is because of the actual or perceived race, color, creed, religion, ancestry. So the example that's often given here is you're in a traffic accident with somebody, a fender bender, you get out, you're having an argument. In the midst of an argument, the offender punches the victim and then says to the victim, you're a stupid white bitch. Sorry, I'm using white woman because that happens to be what I am, so I'm not offended. You stupid white bitch, I hate you, and punches them. Well, the issue can be, was it the frustration over the traffic incident, or was it the person really doesn't have a good feeling towards white females? So mixed motives can be very different. Judges, a lot of judges don't really like some of those cases. At least in Cook County, they want cases that are a lot clearer. So just bring that up. Mixed motives are often an issue. If you've proven, number one, that a misdemeanor was committed, and you've got the proof there, and you have that it was committed by reason of actual or perceived race, color, creed, religion, ancestry, then you have that the offender has committed a Class 4 felony. A Class 4 felony is the lowest level felony in the state of Illinois. Now, that can be very frustrating with our victims because they feel like they've been the victim of a heinous crime, which for them is heinous. However, in the scheme of what felonies are in the state of Illinois, a Class 4 felony is the lowest level felony. And the lowest level felony is 1 to 3 years of probate, 1 to 3 years, of time in the penitentiary or probation. That's a very low sentence. It's the lowest sentence that there is. On top of it, you have to have a second hate crime for it to raise the level of a Class 2 felony. So it's got to be a second offense. It becomes a second offense. It can become a Class 2 felony. When I say second offense, there has to be that conviction for the Class 4 felony. So you need 2 to get to a 2. Now, to sort of give you an idea, a Class 2 felony in the state of Illinois is something like a burglary to auto, a possession of a stolen motor vehicle. A Class 1 felony would be things like robbery. Now, this isn't technically a hate crime, but we do have institutional vandalism. That is with regard to property that is a location or real property or within 1,000 feet of a church, a synagogue. Oh, you get to hear some sirens from here in Chicago. I don't know if you can hear those on my speakerphone. But location of real property or within 1,000 feet of a church, a synagogue, a mosque, etc., used for religious purposes, in a cemetery or other place of burial, school, educational facility, or a dorm, or a public park or ethnic religious community center. If you commit vandalism in one of those places, it is determined the class of felony by how much vandalism. Now, this also has to be by reason of actual or perceived race, color, creed, religion, ancestry, just like the hate crime. But what's particularly important here is, remember I told you, is by reason of actual or perceived. It really doesn't matter if the offender has the right victim. If they think they're battering a black person and they're not black, if they think they're battering a gay man and they're not gay, if they think they're vandalizing a church and it's not a church, it doesn't matter. It's still a hate crime. It goes to what the motive of the offender is. And if the offender doesn't really have it correct as to who there is they're battering or who it is they're committing the vandalism for, well, you know, their stupidity doesn't exclude them from a hate crime. Now, for this institutional vandalism, I'll just show you something, that the difference between institutional vandalism and hate crime. As you can see, an institutional vandalism, based on the same reasons of actual or perceived race, color, creed, or religion, the lowest level felony is a Class 3 felony. So in other words, institutional vandalism is a higher felony than an actual hate crime against a person. The level of the Class 3 felony is for 2 to 5 years in the penitentiary or probation as well. If you commit 2 institutional vandalisms, and both of them are convictions, one right after the other, or one and there's a sentence and then there's a conviction on a second one, that becomes a Class 2 felony. And I already described you before, Class 2 felonies like a burglary, a PSMB, that kind of thing. What's important for our victims on these cases in particular happens to be their sentencing. Like I said, sometimes it's very difficult for victims of these crimes to understand that it's the lowest level felony in Illinois. That's not my decision. It's not the state's attorney's decision. It's what the legislature has decided is the level of felony it's going to be. So what we try to emphasize to our victims is the importance at the time of sentencing. Because even though the sentence for the offender probably won't give the victim back what it is they want, which is a feeling of wholeness, a feeling of feeling safe again, we do have a chance of reaching for them and reaching to them to give them some satisfaction. Because the first thing that we emphasize to all of our victims of hate crime is, under the law, they are allowed to provide a victim impact statement. Not all crimes in the state of Illinois allow you to provide a victim impact statement, but a hate crime does. And me personally, although as a state's attorney I'm allowed to read that victim impact statement into court, to put it on the record and put it in the court file, on almost every one of my cases I've insisted on the victim coming forward and the victim taking the witness stand and reading their victim impact statement. My personal experience after all of these years is that it is a great release for that victim to be able to sit there and talk about how this crime impacted them, not just at the time of the crime, but in the long term. This often has a great impact on the judge who actually has the victim right in front of them. And in addition, it gives the victim a position where they are now in the position of power because no one can interrupt them, no one can knock them down, no one can graffiti their garage. It's very important. The other thing we try to emphasize to our victims is even if the offender, who in our experience, in my experience in particular, is usually younger, not always of course, but usually younger, early 20s, late teens, if they get the probation, because it's often their first time conviction, they do have to do 200 hours of community service. 200 hours of community service is not an option for the judge, it's a requirement by the state statute, which we have used in a variety of ways to try to make an impact on those 200 hours of community service. What we often do is we'll have them enroll in educational programs, if it's a criminal damage property, to like religious pictures or objects, so they can learn about the religion against which they just committed a crime. We, for a long time, worked on something called the Hate Crime Probation Program, in which it was Chicago Police, the Adult Probation Department, the State's Attorney's Office, and our providers. And if I were to have someone else sentenced to probation to hate crime, I would do this again. The first 25 hours of that hate crime probation program, we worked with the Salvation Army, who had a 25-hour cultural sensitivity training and anger management training, so to sort of try to retrain these young offenders to think in different ways, and if they didn't think in different ways, to at least act in different ways. If after those 25 hours, those offenders were deemed to be not dangerous to the community, the final 175 hours of the community service, they were placed, just like for criminal vandalism, they were placed in the community against which they offended. This was often great because they had 175 hours where they had to work with people. And ironically, I had one offender who was in a hate crime probation program where he worked and he had committed a hate crime against an Asian American. He actually ended up subsequently being hired by that Asian American organization because things worked out so well. I'm not a pie-in-the-sky optimist, but that was just a nice end to that story. Fines include up to $1,000, and there are also civil damages. Now, we have private attorneys in Cook County who also file civil damages on behalf of victims if you want to try to get some money from offenders. The one very nice thing about these civil attorneys who know the work we do with hate crimes, they wait until after our case has been disposed of before they file that civil action, unless our case takes 3 years, which is highly unusual. This way, we don't have an additional motive that we have to tender to the defense, which says, oh, the victim's only doing this because they want the money. So anyway, sentencing is really important in these cases. Investigation, motive. We work pretty closely with the Chicago Police, both through our felony review unit, who approves or doesn't approve all charges that the police call felony review for, but also when we're in the community justice centers or you're a state attorney that handles one of these cases. What we work very closely with the police and our own investigators is the very first thing we try to get is the motive. And of course, any of you have done any of these cases, any sort, motive is so important. We look both at the comments at the time, written statements and gestures, any emotionally charged words that they used, words that are particularly offensive, and I think you can figure out what those are. Graffiti, carvings. I've often hit pay dirt, quite frankly, with tattoos. Tattoos are a great way to see what a person thinks, and they're not necessarily thinking about their tattoos when they go out and commit a hate crime. If you see those tattoos right away, you should have your investigator or your police officer take photos of them, because I've had offenders with particularly racist tattoos. By the time of trial, they've tattooed over those racist tattoos. But for me, it doesn't matter because I have that lovely 8.5 by 11-inch color photograph of the original offensive tattoo, which is really, really nice to pass around to the finder of fact. All of these things, including those tattoos, the graffiti, the carvings, they're the defendant's calling cards that we always try to use to show what their motive is. it's really important, not just with the motive, but preserving and collecting evidence. I talk to not just police with trainings, but also if I get a case where the victim hasn't had much time to really kind of recover yet, the first thing I find victims often do, particularly if it's a criminal damage to property, they and those cell phones can go. Times have found that people will throw out the screwdriver, or, I know this sounds silly sometimes, but the spray paint can. Getting that spray paint can, because spray paint cans actually are not legal, getting that spray paint can, which you then show is the exact same color on the lid as the spray paint on the garage, can be really powerful, as you all know. Those little tiny things that the jurors or the judge can just slam onto are really important. Even if there isn't any of this evidence, I find it's really helpful for an evidence technician to come out, even if they dust for prints or look for stuff, because I then can put that evidence technician on, particularly at a jury trial, and help them to explain negative evidence. I know we've seen NCIS, I know we've seen CSI, and all of these fabulous crimes that are solved by one little hair that they can tell you everything, or time of death and what the last meal was. I don't know about anybody else, but I've never had a murder where they've told me time of death to the exact minute or what their last meal was. And it's the same way with hate crimes. Nothing is ever, you don't get everything tied up in a little bow. So I try to have that evidence technician there and explain how, well, the victim did paint over this, and guess what? We couldn't unpaint the paint that the victim painted over it, so this is all we have. What I also find is important is in the police reports to describe the victim's demeanor, because sometimes, by the time the victim comes testifying in court, of course they're often calm. They might look a little nervous, but they're not usually crying or shaking or whatever. Not that I like my victims to cry and shake, so don't take that the wrong way. But I like it when my investigator puts that in their case report that victim was shaken and was crying or upset. Proof of other crimes, I like to mention this. We are allowed in the state of Illinois, and I'm sure most of you are too, we are allowed to file a motion of what's called proof of other crimes. These are defendants' previous both charged and uncharged acts that we have to submit in writing before trial to a judge after we give a copy, of course, to the defense attorney. And we let them know why we think these charged and uncharged acts go to show the defendant's motive, show the defendant's intent, and show the absence of mistake, like, oops, the defendant really meant to do something else in this person's garage, not the hate crime words that the defendant used. Because we can often find on some of these other maybe assaults or criminal damage to property or these batteries that are listed on the rap sheet, when you start looking into them, you can sometimes find there's graffiti on an overpass that might say something about a different race or might say something about a different religion. And you can bring that in. You can bring that in and explain to the judge on these other incidents, this person is now revealing what their true motive was in this particular case. You can bring it in even to show identity. Sounds kind of crazy, but we had a guy who liked to do graffiti, and we were able to bring in enough of his other graffiti because he had a certain way of signing things that were able to show his identity. You have to be able to prove up those individual cases by at least one witness. Sometimes it's the victim, but if you can get by with a police officer, that's just fine. What this does is it makes what you might have as a weak case, it makes it strong, because it allows other victims to testify, other witnesses to testify on other cases. And it has a really good impact on the judge or jury, because you might have a person here who has no criminal background, so they're never going to hear about any prior convictions, but they're going to hear about these other actions that this offender took that, whether they were convicted or not, go to their motive. What I personally find is that this happens to encourage a plea, because now a defendant is faced with not just the victim on my hate crime, but victims on a variety of other cases that they've never had testify against them. So what it means is you then have your parade of 2, 3, or 4 victims. You can use this. I try to use it sparingly because sometimes the courts frown on them. They don't want to bias a jury against them, although that's kind of ironic. Our standard is the probative value outweighed by the prejudicial effect, because as judges understand, if it wasn't prejudicial to the defendant, I wouldn't want to introduce it. If it doesn't show he's guilty, why would I want to bring it in? So they weigh it not just, obviously it's prejudicial, but is its probative value still great enough? And they will let it in. Just make sure you use it sparingly, and if you've got a really strong case, you might not want to do that, because at least our appellate courts here do look at proof of other crimes pretty carefully, because they want to make sure the defendant wasn't sandbagged. Documentation. I talk about this periodically, in particular with the police, and what it means is sometimes I have police file supplemental reports. What I tell them is, if in their documentation, if they didn't write it down, it didn't happen. Judges don't believe it, juries don't believe it. If it's not written down, you can hear the cross-examination. Officer, you were trained at the academy, weren't you? Well, yes, I was. And the academy trained you to put in all really important facts, didn't they? Yes, they did. Well, wouldn't it be important exactly the words that this defendant used? Well, yes, it would. But you didn't do that, did you, officer? No, I put in a summary. You don't want that. You want the exact words, and you want it written exactly the way they were. So in that same manner, I tell them, never, ever use the 2 words, verbal altercation. My highly legal thing here is just yuck. I talk to judges, they don't like it. Jurors don't like it. If it's an argument, say it's an argument. They don't. Let's face it, a lot of jurors, a lot of judges don't like playing those playing with words. It's an argument, say it, and keep it that way in your documentation. As I talked before, for use of exact words, please put them in quotes. Have your officer put them in quotes. I can't tell you how many times officers then get cross-examined about, well, if it was exact words, you would have put it in quotes, wouldn't you? So just tell them to do it. I also try to tell them to avoid statements which minimize an injury. This is particularly true in my the battery cases that you might have. I can't stand words, and I see them in all kinds of case reports, no serious injury, or when it's an assault, just an argument. What I tell them to say is the victim was told to seek medical attention. At this time, the victim refused. That way, the police officer is not making any judgment call as to whether the injury was serious or not. And as far as just an argument, I say an argument, don't use the words just. If there was no touching, if there was no battery, believe me, we'll get that out. But just definitely minimizes. So the documentation, I don't know what your experience is. My experience is you can often win or lose your case and your documentation. And what I find particular with hate crimes, since these are things that are specific to hate crimes, and often since they're just class 4 felonies, sometimes people aren't taking them as seriously in their investigation as possibly they should. I try to spend extra time with the officers that I know are going to be investigating them to emphasize these things on documentation. Because although they're the ones with the intake portion, you're going to be just like me. We're the ones that have to try this case in court, and we want as strong a case as we can possibly have. So I spend a little time talking to my officers about documentation. And my personal experience is if they've forgotten something, you're usually on the case early enough before discovery is complete. Have them write a supplemental report. You know, judges really appreciate it if an officer says, you know, Judge, I was reviewing my paperwork and I realized I was missing A, B, and C, and I felt it was important to put in a supplemental report with A, B, and C in it. Judges like that. It makes the police officer look like they took it seriously and they cared and they thought about it after the couple hours they spent processing the case. Working with victims. We have a felony review unit where we go out and interview victims of or alleged victims of crimes that are potentially approved and come into the felony courtroom. If they're not, they go into misdemeanor courtroom. I find there are some cases, just like probably you do too, where it's more difficult for victims to talk about than other cases. I find that in particular with rape. I find that in particular with child abuse, and I find that in particular when you have a small child that has to come in and testify about what they saw happen right in front of them. Working with victims in hate crimes, I try to make sure they use their own words, except for when describing the defendant's words. I don't want my victims to clean up the defendant's words. I had a very nice African-American father who was on a bus with his child, and there was a 20-something Caucasian guy who was calling him the N-word, and the father kept saying, yes, he was yelling at me that I was a nasty African-American. And I said to the father, that is not the word that he used, is it? And he said, no. I said, what word did he use? He said, he used the word nigger. I said, sir, you are going to have to say that out loud in court, because that's going to have a bigger impact on the judge, and it's the word that the offender used. So you got to prepare them, because these victims who are targeted because of who the offender believes they are, and they have no control over that, they have to use those offenders' words. You're going to have to help them be comfortable in using them. And the reality is they probably don't want to talk about it, and you know that. So it's really important, and all of you know this in working with any of your victims, you really have to establish something of a rapport with them. They have to trust you that you're not asking them to say these words because you just want to hear the words in court. They have to trust you that you know these words need to come out so that you can get a conviction. And they have to come out so the judge can hear it and the jury can hear it. I always try to tell them that I have to ask them the difficult questions, and I'm not asking them for any sort of prurient interest or I just want to get some exciting things that I heard happen. I've heard these cases in over 23 years, dozens of times. I've heard horrible cases many, many years, but I have to ask them these difficult questions, because sometimes the case that they think might be a hate crime might not be a hate crime. It might be something else. But I need to ask them that because we need to send this case where it really belongs. Is it a misdemeanor really, or is it a felony? Once we do decide, it's really important to be realistic about the time frame of the case. I don't know what it's like in other counties, but here in Cook County, what we refer to as our two phrases in misdemeanor court is, if you blink, you miss it. So if the court call says 9 o'clock, be there at 9 o'clock. Whether there's 200 cases on the court call or not, it moves fast. So if you blink, you miss it. For our felony cases, what our phrase is hurry up and wait and wait and wait some more. And if it's a felony case, it usually takes a couple of months to get all the discovery that we need to be able to tender to the defense, and then they have some time to do their own investigation to tender discovery back. I try to be as realistic as possible with people so they're not expecting a resolution in a month. In that same manner, I try not to oversell or undersell the case of the judge. We have some judges here who are great. We have some judges here who are not. I don't get to pick my judge. And I don't try to tell them, oh, we have the best judge. We're going to get 2 years penitentiary time on this guy with no background. Really, that does nobody any good if that's not a realistic end to the whole case. So I just try to tell them what the options are and what I think, based on my experience, what a reasonable sentence might end up being in front of a particular judge. What I find most important to help victim and I get through all of this is I try to refer them to support. to our victim witness unit, or if they have support in their own community. It's really, really important over this time frame because, of course, as you know, if you've handled a hate crimes case, and if you haven't, you will learn this, they feel particularly vulnerable because it was their whole community. Their whole community, if they're gay, all gay, they feel like all gays were attacked. They were attacked because they have no control over the fact that they're gay. So having them have support is really important to help you get through this case with them. Now that being said, I'm pretty adamant about this. I don't conduct interviews and prepping my witnesses on a case with their support person there. So if they come with their counselor or they come with their someone from, like we have a Hasidic Jewish committee here, and I prosecuted a case against 2 Palestinians who targeted the Hasidic Jewish community here. They had some members of their community come. I won't conduct the interview with any of their support people there. And this is the way I explain it to them, and I explain it to you. Anytime you have anyone there while you're interviewing your witness, create another witness. And then I have to tender that person's name to the defense. And so as I say to their support person, number one, you're not going to be able to be there when trial is going on if you become a witness to this victim changing their story or whatever, and you become a witness if you sit here while I'm interviewing. So I tell them, you don't want me to have to tender your name. You can just wait outside and we'll be done in 15 minutes or 20 minutes or whatever it is. I tell them my most important thing right now is to protect the integrity of the case. So I try to prevent any of them from being on the interview. If you've already established a bit of a rapport with your victim and you've reached out to them and you've already referred them to support, I've never had a problem with this. The only people I've actually had a problem with was 1 or 2 support people who came along. But once they find out that their name has to be tendered to the defense attorney, they usually kind of back off a little bit. Bias indicators, these are the bias indicators that I look at when I'm trying to decide whether it's a hate crime and a felony that we can prove and how we're going to prove it. Are there racial, ethnic, gender, cultural differences between the defendant and the victim? It's not always the case, but they're often in different racial, ethnic, or gender groups. Is the victim in a minority group for that location? That's often a big sell for me to know that this was based on this victim being somewhere that some other person decided they didn't have the right to be. Was the victim engaged in activities promoting their group? I also look around certain holidays for that, Rosh Hashanah or whatever, to make sure, this goes on with the next one, coincides with a holiday or significant date in their religious calendar or whatever. And I also try to look at the historic animosity between groups. Our victims can feel a variety of ways: isolated, degraded, scared, suspicious, powerless, depressed, and they often minimize. I find it ironic for me, I find that these are some of the same things that sometimes my rape victims and my child sex abuse victims feel. Some of the same kinds of reactions, even though they're very different kinds of crimes. I think my hate crime victims just feel very, very vulnerable and want to show that they're handling things or they feel like they're very alone. These kinds of cases take a great deal of hand-holding and empathy because your victim feels very vulnerable. If you're going to work with hate crimes and you're going to be effective in what you do, you can't wait till the hate crime happens to establish a relationship with your community. You need to work with your community now. You need to be prepared to attend community meetings. You need to conduct trainings to educate about hate crimes. You need to work with court advocates to assure their presence in court. And please, please, please talk to your victims. Don't have them make public statements. These last two I just want to mention briefly. Court advocates are people who come to court on individual cases to support the police, the prosecutor, and the victim. They come to court, they're not paid, they stand up when the judge calls the case. They are there to let the judge know by their presence that that case had an impact on their community, which is wonderful because judges have 200 or 300 cases on their call. And when they see court advocates there in a particular case, they can distinguish that this case is different from the 250 other cases they have on their call, because this case, people care enough. They care enough to come to court for no pay and to just volunteer. I try to work with all my hate crime victims to let them know court advocates come to court on their behalf. And if a victim, the hate crime victim, wants to come to court, on a day that they're there, they meet with those court advocates. And they feel highly supported by their community. They know they're not standing alone. Their community members are there with them. In addition, and I've had, I believe in straight talking with my victims and my witnesses. I was at a meeting once and there were 700 people at the meeting, and suddenly I just gotten a case, but I hadn't met the people yet. I'd literally just gotten the case. And I have someone standing up at this meeting of 700 people talking, and I realized, oh no, that's my case. So I went and talked to the person afterwards, and I told them if they wanted our case, and it happened to have taken place in Boys Town here, on Halstead Street, which is largely an LGBT community. It's LGBT friendly. I said if they wanted to use their case as a, as a soapbox to let their political opinions show, they were more than welcome to do that, but then don't expect me to get a conviction. Because every time they say something about that case, someone's going to be recording their statement. If they want me to get the best possible sentence we can get in court, they needed to not say anything to the media, and surely not at a meeting of 700 people. So they took that as a suggestion and didn't say anything else, and quite frankly, we got a nice sentence. A few more issues. Be careful about filing a civil suit during a case, because that comes out as a bias if the victim's only wanting to get money. When you're talking to your victim about possibly suing the defendant for damages, remind them you can't get water from a stone. Remember, on hate crimes, just a few issues. Your court advocates can be your closest friends and support your victims. You be careful as a prosecutor. You don't want any ethical issues coming up on you because you have made statements to the press or out in public. Remember, no matter where you speak, if it's a public meeting, anything you say can come back, bite you in the butt. And then finally, the most important thing here is don't lose the forest for the trees. I prosecuted my first hate crime back in 1995, and it was a gay man who was going to gay bars in a nice part of Chicago. My offender decided he was going to go to gay bars because he felt if he picked up a gay professional, that gay man would probably, since he was gay, probably not have a wife and children. And if he was professional, probably made some decent money, so we would have some good stuff at home. So the offender decided, well, if I go home with a gay man who's single, I'll probably get some good stuff in their house. So obviously, in my mind, the motive was twofold, both to take something from the victim and targeting gay men. The offender got brought home by the victim that night, and they were in the victim's apartment, and suddenly the offender went and grabbed the victim's titanium golf club, bashed the victim's head in several times, took the golf clubs, took a laptop, took a cell phone, took a camera, took a bunch of stuff, and left the house. Well, we had a trial. The defendant was found guilty of home invasion. The defendant was found guilty of armed robbery. The defendant was found not guilty of the hate crime. Well, armed robbery and home invasion are each Class X sentences, a minimum of 6, a maximum of 30. This defendant was sentenced to 12 years in the Illinois Department of Corrections, far more than you can ever be sentenced to on a hate crime. So I got 12 years on a guy who wasn't a very nice guy and deserved to be off the street. My victim was upset. My victim was upset because the defendant was not found guilty of the hate crime. So I tried to reassure my victim that I'm sure that it hurt their feelings and made them feel terrible that he wasn't found guilty of the hate crime, but let's not lose the forest for the tree. This guy got locked up for 12 years for targeting you as a gay man. So that would just be my final phrase to you: don't lose the forest for the trees. Thanks.
Well, thanks so much to the APA for including Not in Our Town in this webinar, and to Joy for her tremendous work on hate crimes prosecution in Cook County. I want to just talk a little bit about what I'll be discussing today. We're introducing a new film called The Prosecutor Stand about the hate crimes prosecutor in San Francisco, Victor Wong. We'll be talking a little bit about the hate crimes reporting gap and why it's so important for prosecutors to engage in addressing this serious challenge. Again, the role of prosecutors in hate crime awareness and enforcement, and then how to engage communities in reporting and prevention strategies, although that is an ongoing and longer discussion that we won't have time for completely in the session. We're involved, Not in Our Town is in a collaboration with Department of Justice Community-Oriented Policing Service on a project called Working Together for Safe, Inclusive Communities. So there are a few elements to this project. One is 5 new films, including a prosecutor stand that you'll be introduced to today, and a number of others. I'll talk about them at the end. NIAT.org/cops, which is a specific site for law enforcement to find resources in films and news stories about best practices. There are video action kits and discussion guides for all the films. And lastly, something I really hope you will become involved in, and that's the Law Enforcement Leaders Network. We're looking for leaders, people who are actively engaged in hate crimes prosecution, hate crime prevention, hate crime investigation at the police department level, who can help inform this movement and act as a peer group so that you can share ideas with each other. So I hope that if you're interested in what happens, and if you have a good story, please share it with us and become involved in the Law Enforcement Leaders Network for this DOJ Cops Not in Our Town collaboration. Again, this is the new site that's in beta. It's NIAT.org/cops. You can find it there if you have a chance. Please take a look at it before it's officially launched and maybe have some comments for us. As you can see, you can find case studies, film media, tools, and resources. This is a deeper look into the site, and you can see that you can sift through and find materials by profession. So you can find materials that are specifically about prosecutors and their work or for prosecutors. I hope you'll look at all of it, but there may be some specific tools you'd want to use. I want to tell the billing story, which is how Not in Our Town began, because I think I tell this everywhere I go because I think it gives people a good understanding of what Not in Our Town is all about. We were lucky to tell the story of the actions of people in Billings, Montana, and standing up to hate. These actions occurred in the mid-90s, and yet they still resonate. So there have been a series of hate crime attacks in Billings. White supremacist groups decided that they wanted to make the Northwest their homeland, and they were targeting one of the largest cities in Montana, which is Billings. So what happens is that the attacks are met by community response. So when an African-American church found that there were skinheads that would come to this very small church and stand in the back to try to intimidate the congregation, members of other houses of worship sent their congregants, and the skinheads went away. When a Native American woman's house was vandalized with racist graffiti, members of the Painters Union came to paint over the house, and 100 neighbors showed up to watch. The culminating event in this story occurred when a brick was thrown through the window of a 6-year-old boy who had placed a menorah in his window for Hanukkah. People in the town knew that this was becoming dangerous, and they wanted to make sure that nothing else happened. So they started putting menorahs in their windows, and the local newspaper printed a full-page menorah and urged people in the town to do the same. There were additional attacks after this happened, but the town stood firm, and that year, that Hanukkah season, that season between Hanukkah and Christmas, there were 10,000 menorahs in windows. And the actions stopped. The white supremacist actions stopped. Not that the challenge of hate has gone away in Billings. It persists in many places, but this series of attacks was dealt with at the community level very successfully. That story spread to communities across the country. It's now part of the Not in Our Town movement. It's been used in hundreds of communities and in other parts of the world. I think there's some key things that we learned that are applicable to prosecutors as you think about this. One is the message from the police chief, who played a vital role in what happened in Billings. He said silence is acceptance. And he said if a police chief, you can substitute prosecutor, takes a visible, active role, then there's an assumption that if a police chief doesn't take a visible and active role, then there's an assumption that everything's all right. And if you remain silent, that means you accept hateful acts. So he was pivotal in this endeavor, and it urged the community to become involved. I think the second lesson was that the community made their values visible. They found a way to express them in many different ways, and we found that to be true in so many other places that have engaged in anti-hate or anti-intolerance efforts, and in not in our school efforts as well. Again, the third lesson was cross-community involvement. This wasn't just one sector of the community. It wasn't just action by law enforcement or even just civic leaders or school leaders. It was the everyday people. It was a way for many people to get involved and to surface diverse members of the community to engage in this anti-intolerance effort. That is a key message of Not in Our Town moving forward. So, as many of you know, a hate crime is reported nearly every hour, but that only scratches the surface. If you look at the statistics from Bureau of Justice statistics, there's a huge gap in the number of hate crimes that are reported and the number that actually occur. So if you look at the 2011 stats, which are the most recent that we can see, there were about 6,222 that were reported by local law enforcement to the FBI. A horrible number, to be sure, but the actual number that BJS estimates actually occurred is 217,640. That's a huge, huge, enormous gap, and there's, I think, tremendous dysfunction and trauma inside those numbers. So how do we address that, and what is the role of prosecutors, law enforcement, and community members? Because I think all of us have to acknowledge that many, many people are reluctant and never report these crimes to police for a whole variety of reasons. So I think our role as communicators is to help support law enforcement's efforts, but the community's efforts and willingness to report to law enforcement. So some of the things that we've learned from this most recent study and from what BJS has done is that 2 out of 3 hate crimes are not reported to police. They're just never reported. 25% of violent hate crime victims don't report because they don't believe the police could or would help them. We are looking for best practice examples from law enforcement on hate crime reporting. Who's doing a good job? How are prosecutors helping with this? If you have examples of really good hate crime reporting practices, please share them with us. So prosecutors are essentially storytellers. How do we change the narrative on hate crimes from the community to the courtroom? And I think we've heard this from many prosecutors, from police. Hate crimes are too hard to prosecute. There's no time to investigate. Judges and juries don't understand. And I think all of that may well be true. All of these statements may be true. But to get to this larger truth, the extent of hate crimes, the damage, the divisions they cause, I think we all have to do better and change how we present the story. One of those stories that we have been able to tell is through a film we presented in 2011 called Not in Our Town, Light in the Darkness, PBS film. It tells the story of the community of Patchogue, New York, that was awakened when 7 local high school students were charged in an attack that ended in the killing of Marcelo Lucero. He was an Ecuadorian immigrant who had lived in this community for 13 years. He was stabbed to death in an attack. The police quickly found the perpetrators, these young people, and prosecutors uncovered the extent of this damage. It seemed that these young people had been roaming the streets of this town for months and months, looking for quote-unquote Mexicans to beat up in a sport they called wiener hopping. So there were many victims that were discovered after this crime was committed, after Marcelo Lucero was killed. and it was the prosecutors who uncovered the extent of the crime. As the police missed many of these reports, I think there's a whole layer of challenges with hate crime reporting practices there, but also with the community being reluctant, with language problems, many different challenges in that community. The prosecutors in this case, I think, played a vital role in upending the story and dealing with this. If you've seen the film, you know that all of the perpetrators who were caught that night were sentenced. 6 of them pled guilty and received sentences, and that included hate crime charges. Jeffrey Conroy, a 17-year-old who was prosecuted as an adult, received manslaughter charges and with hate crime enhancements. So again, I think the prosecutors played a vital role. So the film's available in 27-minute and 54-minute versions. I hope that you consider showing it in your community, to your office, and having a discussion about, I think, the really powerful work that was done by these prosecutors and this community to expose the level of the problem and try to address it in the aftermath of hate. I think the ultimate lesson is, what do we do before this happens in our towns? How can we learn from the trauma of one community so we can prevent the next hate crime? You'll see extended interviews with Suffolk County prosecutors on the site nias.org/lightinthedarkness. I'm here today mostly to talk about our new film called Prosecutor Stand. It profiles Victor Wong, the hate crimes prosecutor. It's available now for screening. It'll be online soon, but you can be in touch with us straight away if you'd like to set up a screening soon. There are 3 cases that we look at in this 22-minute film: attack on 2 Mayan dishwashers outside a bar in the Tenderloin district, the stabbing of a homeless African-American man who was never found to prosecute, and nonetheless the case was moved forward, and the beating of a transgender woman at a transit station in San Francisco. I think one of the lessons from the case, and again I hope you have a chance to see it, is that in looking at and prosecuting the attack on the immigrants in the Tenderloin, prosecutors uncovered an extensive network of skinheads that are operating in San Francisco. And I think many people say, oh, San Francisco, liberal city, they don't have a skinhead network. It was, I think, indeed powerful and quite large. And if it hadn't been for the persistence and the investigation on the part of both the police department and the prosecutors, this would never have been revealed. And if it hadn't been for the fact that they knew that they needed to prosecute as a hate crime, we wouldn't have learned about this. So Victor Wong shares these 5 lessons for law enforcement that he's learned from his work. Again, be proactive in community outreach, establish a specialized hate crimes unit, both in the police department and in the prosecutor's office. Form a law enforcement community coalition. So as you're working on cases, you can, or as you're trying to learn about what's bubbling up in the community, you have some good sources. Form a regional hate crimes task force. I hope many of you have that. If not, there are examples on nia.org/cops about how to do this. And then work closely with victim witness units. They did that very carefully in the case with the immigrants who were attacked by the skinheads. He also has 5 lessons for communities, which is outreach and education to communities on hate crimes. Why is it important to recognize them and report them? Organize and react when something takes place. Work on and with law enforcement. Bear witness. So I think one of the things that was troubling in our community was that there were very few people who showed up when the witness testified in open court, when the victim actually testified. And having that kind of support, I think, is really important to bolster victims. Bear witness and intervene early. Engage early when you hear problems bubbling up. Those are lessons for communities. We have a few upcoming films from that we're providing to law enforcement and communities for free. You can download them. You can order DVD copies and guides. One is this film, Case Against Hate, a Prosecutor Stand. 5 Lessons from a Hate Crime Detective is a short film that can be used in roll call or short meetings. It profiles Ellen Vest, investigator from the Sheriff's Department in San Diego, who has deep experience with hate crimes investigation and uncovering white supremacist gangs. And then Not in Our Town, Waking in Oak Creek. It's a half-hour film about the actions in Oak Creek, Wisconsin, which was the site of one of the deadliest hate crime killings in recent history, where 6 temple members were murdered by a white supremacist, and a police officer was shot 17 times and amazingly lived to become involved in the community response. We're premiering that in Oak Creek this week. So if you're interested in any of that, in screening those films, you can contact us. You can go on our site and find a way to host a screening, or be in touch with Michelle Gahey-Kloss in my office or myself. So film and viewer guides are available for all of these on NIAT.org/COPS. We encourage diverse community partnerships, again, with all of these players. Key lessons we learned from Victor Wong and from our groups in Not in Our Town around the country. More resources on NIAT.org and NIAT.org/COPS. We're building a set of books and guides. This one is recently was launched, Building Stronger, Safer Communities, Lessons from Not in Our Town. And COPS has a robust set of tools that you can use in working on hate crimes prosecution and reporting. So thank you very much for this opportunity, and please be in touch if you'd like to set up a screening or become part of the law enforcement network.
Thank you, Patrice, for the excellent presentation. The APA webinar and materials are available at no cost on our APA membership website, and we will be notifying you via email when these materials become available and how you can access them. If you have any questions or concerns, please email us at webinars@apainc.org. Thank you for attending, and please do not forget to fill out the survey evaluation to be entered in the drawing for a free 1-year APA membership. Please visit apainc.org for more information and join us for our next Final Fridays webinar. Thank you so much.